All right, folks, we're here with none other than the Honorable Premier Wayne Panton, who's going to speak to us about the Anti-Corruption Amendment Bill 2022 that is going to be coming to the floor of Parliament relatively shortly here in December. So good afternoon, Premier. Thank you so much for taking a few minutes out of your day to spend with us.
Oh, good afternoon and pleasure to be here with you. Thank you.
All right, so we're recording this for the benefit of our viewers and the broader audience here in the Cayman Islands. Just kind of clarify a few things that have been circulating in the community in relation to what some people say are some very serious concerns about the Anti-Corruption Amendment Bill.
All right.
First of all, let's just get to the crux of what this is. There's a section in the existing piece of legislation, the existing act, which is a 2019 revision, that is section 17, and it talks about abuse of office.
Right. So, Sandra, let's start with the memorandum of objects and reasons that accompanies every bill, as you know, since you're typically familiar with these.
Yes.
Particularly in relation to section 17. The relevant clause of the bill says, clause 7 repeals section 17 of the Principal Act, meaning the existing Anti-Corruption Act, 2019 revision, and substitutes a new section 17, which reclassifies the offense of abuse of office as an indictable offense and increases the penalty attached to the offense.
Okay.
So what's really important there is that it is clearly saying what the relevant effective changes are, what the substantive changes are to section 17. And you'll notice it doesn't say anything about changing the burden of proof or the standard of proof required. And what it does, what it specifically sets out, is that it is trying to change the change to section 17 is requiring to increase, is attempting to increase the penalty attached to the offense. What that demonstrates is a commitment, an intention and a commitment to increase the level of punishment for someone who is found guilty of a commission of abuse of office. And that is quite contradictory to the comments and the statements that have been made in a couple of articles and obviously a number of comments online.
So let's break it down, because we've got different listeners. Some might be lawyers, some are non-lawyers listen to the program. So when we talk about an indictable offense, first of all, it's important for the general public to understand exactly what that means. So that's a criminal offense in which the accused may be incarcerated for a period of 6 months or more. So those are the more, what we consider in law, the more serious offenses, if you will.
Yeah, so for the general public's sort of interest in and for all intents and purposes, this really just means that you can, it's an offense which you end up in grand court, as opposed to summary court.
Yes.
And you have then the option as the defendant to ask for a judge alone trial or a jury trial. And
increasing the penalty. So where do you think the confusion has arisen?
Right. So let's just stick with increasing the penalties for a second.
Yes.
So the existing law, I think, has, let me just pull it up here just to be sure. I think section 17 provides in section 17(1) provides.
So it says summary conviction of imprisonment for a term of 2 years.
Summary conviction to imprisonment for a term of 2 years.
Right.
And then subsection 2, which is distinguished from 1 in the sense that that's in relation to a loan, reward, advantage, or other benefit If you're convicted of that offense, the term there is 3 years.
3 years.
So it's 2 years for subsection 1, which is if a public officer or a member of the Parliament who does or directs to be done in abuse of the authority of his office an arbitrary act prejudicial to the rights of another. So if you do that and you commit an offense, it's liable, and you're liable on summary conviction to a term of 2 years. The second one is if you if in conducting that or carrying out that act, it is for the purpose of a loan, reward, advantage, or other benefit, then you also commit a separate offense, and it is liable on summary conviction for a term of 3 years. So, switching back to the bill itself, what this is trying to do by substituting Section 17, the new Section 17, is it is.
So we go from 2 years to 4 years.
Changing it from 2 years to 4 years.
Yep.
Sorry, the first change really is making it on indictment.
Right.
So you go to Grand Court, and you can, it's triable either way by a judge alone or by jury, and changing it to 4 years. So you're doubling the potential sentence for a conviction under that section, that subsection.
Right.
And then for subsection 2, it is the same indictable offense, and it changes the period from 3 years to a maximum of 5 years. So of course, when you make changes, when you propose changes to potential custodial sentences, what you are trying to do is largely trying to increase the deterrent factor. Increase the level of punishment, so that people will think twice about engaging in anything like that. So that's effectively what the new Section 17 does. Now, where's the controversy? The original bill, the original law, the original Section 17 required the prosecution to be able to prove that you intended to do this, right? It didn't specifically say intentionally. When the bill was done, this current bill was done, and the legislative drafting we're going through it, they're reflecting the ever-evolving sort of legislative style, drafting style. And part of that is to increase the movement or the change to sort of everyday English, so that people understand it better.
Exactly.
And that is the reason why you see a change in the inclusion of the reference to intentionally. Now, that doesn't change what the obligation was on the prosecution previously. It is done as a drafting style change purely to make it more everyday English, so that people have a better understanding.
So in an effort to modernize the legislation and update not just the very, very specific points on indictment and increasing the term of imprisonment, they've used more modern language that some people have now incorrectly, is what you're saying, interpreted that to mean that there's some additional mental element, in law we call it mens rea, that is required for the act to have been committed. And you're saying that's completely incorrect.
That's incorrect.
Yes. Okay.
There's no change. It's the same. The prosecution have the same obligation. What has changed is that these are now indictable offenses that are triable in Grand Court, either way, jury or judge, and the prison term, the maximum potential prison term, has doubled for Section 17(1), subsection 1, Section 17, subsection 1, and has gone from 3 years to 5 years for Section 17(2). So the deterrent factor has significantly increased. In other words, in another language, we're seeking to effectively threaten stronger punishment for someone who is committing this sort of offense.
Right.
Now, in that context, that is entirely different. That reality is entirely different from what has been expressed in at least 2 articles that I've seen in our local media. One was on Loop, and another one was a viewpoint on CNS, Cayman News Service. Now, the article in Loop does not talk about any other change. It simply attempts to represent that the government or Parliament's intention appears to be to make it harder for the prosecution to prove that particularly a member of Parliament has been guilty of an offence. It does not even recognize either the 2 real changes, which is the indictable offence and the increasing of the maximum sentence.
Yes, and I
so
think
increasing
that
the deterrent factor.
You know, I want to say this for the benefit of our listeners. When I read the article in Loop, the thing that stood out for me is this one sentence that says, by having to prove an MP's intent, the job of the Anti-Corruption Commission may now be harder. And I think this is a misunderstanding and perhaps a lack of understanding, really, and how the criminal justice system works. Because outside of strict liability offenses, which tend to be traffic-related offenses, and I sit in court almost on a weekly basis, all offenses, certainly the ones in Grand Court, there is a need to prove intent.
Right.
You know, even sometimes the terminology might say things about negligence, so the specific wording of the act might be a little bit different, but that is where the intent comes in. And then it's for the judge who is, you know, the expert on the law for the benefit of the jurors, if it's a jury situation, to define what in that specific act, what intent means, whether it's negligence, intentionally does something, because every act might have a slightly different wording, seeking to defraud, and what does that mean? What's the actual intent that's required? So I found it interesting that maybe the writer of this article simply misunderstood, from a criminal law perspective, what is required to win a successful and prosecute a successful criminal case in any event. So to make it very, very clear, there is no intent to change any legal element as far as what is required for the prosecution to prove and be successful in a case of this nature.
Correct.
And the law does not reflect that at all.
Correct. So, I mean, it's, I guess you could call it an amateur mistake.
Yeah.
I don't understand why, if you want to write an article like that, ask a criminal lawyer, or ask someone who, has a better understanding. But in a situation like this, you're absolutely right. You mentioned earlier the concept of strict liability. That has very little application. It's quite restricted in criminal law, because the general concept of criminal law is that you must have, not only do you commit the act, or the actus reus, but you must have the requisite intent, or the mens rea, in most cases. Now, there are some examples of situations in which the Parliament and the courts have decided that that the issue is worthy of lowering that bar. So, it ranges from the simple things like traffic offense, like speeding, for example. You don't have to prove that you intended to speed. Right. You just have to prove that you were speeding. Something more serious, more grave, like statutory rape. Those are the types of examples in which strict liability typically exists. Of course, it exists in other branches of law as well. In the law of tort, you don't have to prove intent in those areas as well, even though the impacts can be significant. But certainly in this case, there is no change to the burden of proof and what's required to be proved in terms of mens rea. What is intended, as we have clearly set out, is simply changing it to indictable offence, grand court, and increasing the sentence in both of these subsections. So, you know, I think it's very unfortunate when there's an attempt to mislead the public into feeling like that the very legislators that they elect to ensure that the law of the land reflects appropriate approaches to serious matters when there's an attempt to suggest that they're trying to look after themselves or look after their colleagues.
And
anybody who knows me would understand that
I was just going to
I'm
say
the last person to turn to if you've done something wrong.
Yeah.
You're going to take the consequences.
Yeah. And I was just going to say that obviously, you know, when you read a headline that says, you know, Parliament to make it harder to convict MPs for abuse of public office, this would fly in the face of what you have stood for publicly as Premier of this government, and even, you know, your ongoing attempts to hold parliamentarians and definitely your cabinet ministers much more responsible and accountable than they have ever been held before.
Yes, yes, that's correct. And of course, you know, there may be people who will say, well, yes, you had some examples of some issues. Yeah, I didn't expect perfection. But I can say this, we did not have a code of conduct previously. So, of course, nobody can breach a code of conduct that doesn't exist.
Right.
Now we do have one. Now we're attempting to hold people in their conduct in accordance with the standards that should be expected. And I think that is the right approach to take. We're seeking to do the same thing in relation to Parliament, members of Parliament, and the Parliamentary Code of Conduct.
And where are we, just out of curiosity, with that?
Well, I can tell you that I have all members of government signed up to a Code of Conduct. Way back in March of this year, the Code of Conduct was circulated, the draft Code of Conduct was circulated to all members of Parliament. The only individuals that I had any response from and comments from, questions from, were members of government. I did not get any questions from any member of the opposition.
Okay.
I have gone ahead and I've had my colleagues and myself signed up to our version of the Code of Conduct that we're going to be proposing to Parliament. Now, I have given that version to the Attorney General because remember, the Attorney General and the Deputy Governor are ex officio members of Parliament as well. So it has provision for both of them to be bound by the same Code of Conduct. And the Attorney General is with the Attorney General right now.
Okay.
So I'm hoping to move that forward very quickly. But certainly in relation to this, I thought it was really important that the people of the country understand that your government is attempting to reflect changes to the law to assist in holding people more accountable, not to help to make it more difficult for them to be prosecuted for wrongdoing. Okay. And these changes, we don't actually just conjure these changes up from our own wish list. Changes like this actually come via conversations and discussion with the Anti-Corruption Commission, with the DPP's office, with the Attorney General's office, with legal drafting, and that is how, through a full consideration, that we end up with these provisions. And if what both articles seem to be saying is that the Anti-Corruption Commission the members of the Anti-Corruption Commission, the members of legal drafting, the members of the Attorney General's chambers would all be deliberately trying to make it more difficult to, to prosecute some member of Parliament for wrongdoing. I would encourage them to speak out. If they think that that's where it came from, I mean, any of those offices I just spoke to, they can speak out. This provision, these changes have all come about as a result of a request from one or more of those offices that try to ensure that we have a stronger piece of legislation in place so that we can do a better job of holding people accountable and punishing wrongdoing in an appropriate, fair and balanced way.
Yeah, and ultimately stamping out corruption.
Absolutely.
Wherever it exists.
Absolutely.
Yes.
Absolutely.
Well, thank you for clarifying this. I hope that it's a bit of useful information, again, for the general public to see that perhaps the author of those articles was just a little bit misguided. And really, as Aunt Lotta used to say, making a hill out of a molehill. There's not much to it, folks. But it's important that it still is addressed because, in the face of not addressing these things head on, sometimes that will fuel the fire a bit more. So thank you again. We appreciate the direct responses. We appreciate you going through the respective sections of the law and explaining exactly what is transpiring.
Anytime. Thank you very much for allowing me the opportunity to respond.